I'd like to welcome all members of the small business community who are joining us today. And if you are not a member of the federal government contract small business community, thank you as well for joining us. Today is understanding and avoiding affiliation under small business contracting programs. As stated, my name is Jason Blindauer. I am your tour guide. And without further ado, so this is just about our firm. Yep, bio information. Here we go. And this is just a simple overview of how we have this topic broken down. Affiliation. Now, the first learning point is that the FAR actually has multiple definitions of affiliate or affiliation. And this is really just to kind of give you context. FAR 2.101 provides the general FAR definition of an affiliate or affiliation, and that definition is applied typically for cost principles, such as like the material cost principle, where you have two companies like a parent and subsidiary, where the parent is potentially selling supplies or materials to the subsidiary that's actually a government contractor. That's not what we're talking about today, just giving that to you again to provide context. FAR 9.403, which is the suspension and debarment section, provides a definition of affiliates where two companies are considered related in terms of analyzing present responsibility, and therefore the issue demonstrating possibly not present responsibility can also drag in the affiliated company. Again, that's not what we're talking about today. We're talking about small business affiliation, just providing that for context. Then, of course, FAR 19.101, which provides the definition of affiliate, which is basically almost mirrored, not quite, but almost mirrors what's provided in Title 13 of the Code of Federal Regulations, which is the small business rules. So there is some context for you. So when somebody says affiliate or affiliation, sometimes you just have to make clear that they're talking about the small business rules definition of affiliation and not something else under the wider or general procurement rules. Okay, definition of affiliation, you can see it's right there, straight from 13 CFR section 121.103. And oh, by the way, for everything we're talking about, it's primarily rooted in 13 CFR section 121.103. That is the primary regulation to which you look. And if you want to call that out, if you want to pull that up as we go along, you can see the different types of affiliation which we will be discussing. Basically, what is affiliation? According to the definition, it's when you have another business or a person who has the power to control the small business, in which case, by nature of some relationship or connection between the small business and that person or entity, such that either the individual in the small business or the other business in the small business or the other entity in the small business are considered affiliated. And the reason for the affiliation rules is to prevent, obviously, the frustration of the goals of the small business program. I mean, since the Small Business Act was passed in 1953, as has been a story ever since that time, there have been Trojan horse small businesses, which are basically businesses that are either not technically small businesses, pretending to be small businesses, or in fact are small businesses, but they're basically just doing the bidding of a large contractor who's kind of using them as a front to take advantage of the privileges of the small business program. Obviously, these things frustrate the goals of the small business program to promote small businesses, to grow small businesses, to ensure that resources and benefits are going specifically to that and not to other types of businesses. So hence we have the affiliation rules. Okay, why size matters, and this kind of gets into the virtues and the merits of protecting your small business size and staving off possible affiliation issues. So again, small business status, #1 eligibility requirement for all set-aside programs. Okay, so your small business status, as stated on the slide, is an asset. It exempts you from certain requirements being small, such, a prominent example, cost accounting standards, which can add a certain level of complexity to your accounting cost and pricing, does not apply to small businesses. And then, of course, SBA's presumed loss rule increases importance of protecting and verifying small business status because, again, if there's a misrepresentation over small business status, like, for example, we were talking about Trojan horse small businesses, there is a presumption that damages are going to at least be equal, actual damages are at least going to be equal to the total amount expended on the contract. So that certainly heightens the damages from a misrepresentation. And again, not all misrepresentations are intentional or purposeful. Some of them are negligent. So it's important to pay attention to affiliation and make sure that you're protecting yourself against possible affiliation. Okay, how affiliation impacts small business status. Of course, since the Small Business Runway Extension Act of 2018, if you are in a NAICS code where the small business status is defined in terms of revenue or gross receipts, not in terms of employees, we now look at the average of 5 years as opposed to 3 is what it used to be. And if you have an affiliation with another entity, and this is kind of jumping ahead a little bit, but it's an important point to bring up. If you are affiliated with another entity, that does not automatically vitiate your small business status. It's just now we're looking at the average gross receipts of both entities. We're adding them up together to see if you're still small for the NAICS code for that particular solicitation procurement. So keep that in mind. Yeah, that's covered on the rest of the slide. Okay, affiliation 101. Let's sticking to fundamental principles. What is this really all about? And really, if you want to sum it up in one word, it's about control. Who controls the small business? Is it the intended small business owner or owners? Obviously, depending on the socioeconomic category that small business is in, that becomes more and more important. For example, if it's a service-disabled veteran-owned small business, it's important that the service-disabled veteran or veterans maintain control of that entity because their status was conferred by virtue of the fact that, or with the understanding and assumption that they would maintain control of the entity. And again, losing that control will lead to a frustration of the goals of the small business program. So it's all about control and the many forms that can take. Now, when we talk about control, it can be affirmative control, as in you outright have the power to do something, or a negative control, which usually comes in the form of the ability to block or veto somebody else who ostensibly has the power to do. So both forms of control can undercut a small business's size status under the affiliation rules. And one important bullet point here, and we're going to see this interwoven through the different types of affiliation. It doesn't matter if the control is actually exercised. In some of the years ago, sometimes that would come up as a defense in size appeals before the SBA Office of Hearings and Appeals. Well, maybe we could have controlled what's going on with the small business, but we never actually exercised it. We never actually did anything. It doesn't matter. If an outside entity or person has the power to control, that control exists, and whether it's exercised or not, it can undercut the size status of the small business. And now you can see below 13 CFR 121.103, the various types of affiliation. I call it the 9 baseball players of affiliation because there's 9 players on a baseball field. There's actually only 7 stated in the regulation. There's 10 in the SBA affiliation guide. But depending on, in reality, depending on whether you consider the 70% rule of another business providing revenue to the small business, whether that's identity of interest or a separate category of affiliation. Choose your taxonomy. I call it 9. So the 9 baseball players of affiliation. Okay, and again, these are just reinforcing some fundamentals. Small business, affiliate can be a business entity, whether for-profit or nonprofit. It can be a domestic company, it can be a foreign company, it doesn't matter. If you are entangled, if your small business is entangled with a person or entity for which it's relying upon for resources or support, or that person extends control, and I say resources or support, I mean undue resources or support according to the rules, then it can still be affiliation regardless of where that person or entity is coming from. It can be ongoing, it can be specific to one contract, although when you're looking in terms of size protests and appeals for size protests, size status protests, that analysis is done in the context of a specific procurement. And affiliation is determined at a specific point in time. Again, you know, as businesses grow and change, their relationships change, their possibilities of being affiliated with other persons or entities change, and also as their size kind of goes up and down, depending on the NAICS code for the specific procurement. You know, these things sort of prevent considering the concept of affiliation generally. Rather, it's at a specific point in time, and usually it occurs with proposal submission. That is the point in time in which you are standing up vis-a-vis a particular procurement and saying, I am small for this procurement, or I meet a certain socioeconomic status for this procurement. So that is where we look, that specific point in time generally, to determine whether or not you are affiliated with someone else. And then, of course, like any rule system, there's exceptions, and there's exceptions to the exception, and exceptions to the exception to the exception. But the most notable exception for the affiliation rules comes for Alaska Native corporations, Native Hawaiian organizations, community development corporations. I mean, obviously, you take, for example, an Alaska Native corporation. To get their status, they have to affiliate with a tribal group, and that affiliation does not undercut their small business status, and nor do other entities owned by that tribal group undercut, you know, they're not affiliated or connected with the Alaskan Native Corporation such that it would also serve to undercut its small business status. So for obvious reasons, there's exceptions for that. And then you can see there's some references here to some of the other regulatory sections, SBIR, STTR programs, business loan, disaster loan, surety bond programs. Okay, now we're getting into the first type of affiliation, kind of the most generic way to assess affiliation for many companies is going to be on stock ownership or percentage of ownership. And there's a fairly simple bright line rule kind of for ascertaining control, because remember, this is all about control. If an individual or entity owns more than 50% of the ownership interest or stock in the small business, they are deemed to control. So for example, if you're running a small business and this large business over on the side purchases 50% or more of your stock, well, guess what? You're now affiliated with that large business, and at least for the time that that large business owns that large percentage of stock, you are no longer a small business. Or most likely not a small business, depending on what NAICS code we're doing that analysis in reference to. So looking at percentage of ownership control, typically in terms of stock, I mean, that is the first place anyone looks to figure out whether there's an affiliation issue based on the assumed small business owner having lost control. Now, it gets a little bit murkier when you say you have the person who's supposed to be the small business owner owns a plurality of stock, but if it's significantly larger than any other block of stock owned by any other individual or entity, it may still equate to control. And it works in the converse, right? If a large business purchases 44% of your stock, and the next entity that controls any stock is maybe 20% or 15%, or the next individual that controls any stock, then that large business is going to be deemed to be in control. And again, both these examples are, if this factual circumstance should occur, it's considered non-rebuttable. It's just per se, there is an affiliation, and there's not much anybody's going to say or do about that. So it gets a little more interesting, and this is example 2 of how you can have affiliation based on stock ownership. We're on slide 11, example 2. Individuals or entities own or control or have the power to control what roughly equal minority holdings of voting stock. The aggregate of the minority holdings is larger than any other stock holding. This scenario creates a rebuttable presumption that each person holding the minority interest has a power to control the firm. It's a rebuttable presumption now. It's the small business is given the opportunity to explain why these individuals, when aggregated with the minority holdings of other individuals, don't have the power to control, why that is in fact not the case, but it does create, at least facially, an issue. And then the third place, the third scenario that usually will give rise to affiliation based on stock ownership is if you have no single block of stock is significant, then typically control is going to be seen to be held by the board of directors and the CEO or the president. And again, depending on the socioeconomic status of the small business, that may or may not be an issue. Okay, moving on to the second baseball player of affiliation. Again, we just came from stock ownership or percentage of business ownership, which is, patently the first place anyone would look, and it's the most obvious way to assess whether there's an affiliation issue for the small business. Now we're going to complicate this scheme a little bit more and talk about stock options, convertible securities, and agreements to merge. Now, like a stock option is as stated, you've been given a contractual right to exercise an option to own stock at some point in the future. A convertible security would be some type of instrument, like a debt instrument that you could convert into equity, such as stock. And then agreements to merge. This is at some point in the M&A process, the merger acquisition process, if the understanding amongst the parties achieves a certain firmness, perhaps it isn't a finalized agreement, but certainly it is achieved possibly the level of an oral contract, then that would be another place that could kick in affiliation. So general point on all of this is what the SBA calls the present effect rule. The SBA considers any of these types of agreements or contracts or instruments that provide an option to be exercised or an event to occur at some point in the future that would provide additional ownership over the small business. That's all viewed under what's called the present effect rule. They believe it's basically deemed to have already occurred or already have been exercised. So a stock option does not, save the small business from a possible affiliation issue. If a large business, for example, holds a stock option that would place it as the majority owner of the small business, it's deemed to have already occurred. And here's like the example, and I'll just read this verbatim for the sake of edification. If Company A holds an option to purchase a controlling interest in Company B, the situation is treated as though Company A has exercised its rights and had become owner of the controlling interest in Company B. Company A and Company B are affiliates. In addition, all companies controlled by Company A will be considered affiliates of Company B. So that is how stock options, convertible securities, and agreements to merge can possibly impact your small business size status. Okay, now The exception to the rule, when SBA will not give present effect. If the agreement, for example, is part of the M&A process is merely to open or continue negotiations, basically an agreement to agree, that's not a reason to trigger the present effect rule. The parties haven't agreed to anything at that point. If it's a condition precedent that's basically incapable of ever being fulfilled, that will not be given present effect. And here's our example. Company A and B are in discussion about a merger between the two of them. Both companies' representatives have met several times over the past 2 months. There is neither a formal nor informal agreement to agree unless the two companies have an agreement in principle. SBA will not find affiliation between the two companies based on these open and continuing discussions. Again, discussions about the possibility of a future merger or buyout by themselves are not sufficient to find affiliation. So word to the wise, if at some point a small business wants to go out for sale, at some point in the M&A process, it may lose its small business size status. And if it's during that time period, if it's proposing against government contracts, that could become an issue. Okay, now we're on to the third baseball player of affiliation. Then remember, we're talking about 3 of 9 if you follow my taxonomy. Common management and fairly straightforward. If your officers or principals of your small business are also the officers and principals of another company, well, there's a high likelihood that there may be an affiliation there. But of course, it's not just holding a title, right? We have to look at this in terms of control. Control is key. So if somebody has a fancy title for another company, but they don't actually control anything, then that's not going to be the scenario where you're going to see affiliation based on common management, though it could lead you down a path where some questions have to be answered. So, and then we have an example here of one situation. This is a 2014 size appeal. You had an individual who served as the president of both companies, obviously kicking up the possibility of a common management affiliation issue. And of course, the clever lawyer argument here, which did not work, was the majority shareholder had the right to remove the president at any time. Well, obviously, having the ability to remove the president doesn't stop the president from controlling the small business today and also exercising control vis-a-vis that other company today. So it still was an affiliation issue, and therefore both in terms of gross receipts or employees vis-a-vis whatever was the relevant small business size status, both companies were treated as one. Okay, I think if I'm counting correctly, and keep in mind lawyers aren't good at counting, generally speaking, I think we're at number 4, identity of interest. So identity of interest is the idea that two individuals or the small business in another organization are so closely aligned that their interests basically become aligned and are seen as one. Most common type of identity of interest occurs amongst family members, right? And when you're part of a particularly a nuclear family, things that positively or negatively affect your nuclear family generally are assumed to positively or negatively affect you. Of course, obviously this depends on your relationship with your family, but generally speaking, that's a good assumption. And it's not just family. I mean, you could have two companies that become so close, and we'll get to this. There's a 70% revenue rule to consider when it comes to identity of interest, that their interests can be basically viewed at that point to be identical and thus trigger an affiliation under the rules. Okay, so you see in the slides, the bullets, family relationships, individuals or firms with common investments, firms that are economically dependent upon each other. And like most things in the affiliation space, this gets very fact dependent. Some affiliation issues more than others. So for example, if you're looking at an affiliation issue based on stock ownership, it might be just a simple matter of looking at the stock ledger. But when you're talking about identity of interest, which is at issue in our discussion right now, it can get very fact intensive because you're looking at a pattern and course of dealing over a period of time. You know, how much have these two entities worked together? Did they commingle staff and facilities? You know, I mean, are they really almost acting as a parent and subsidiary or affiliates? Or, and I say affiliates, I mean like corporate affiliates, in using that term generically, not in terms of the small business rules, something like that, that they basically, at some point, the SBA says, well, their interests are aligned and we are going to consider them as possibly affiliated. And then, of course, the rebuttal is providing, you know, facts and information that shows that they are in fact separate, and we kind of look for lines of separation or fracture in the relationship that would place the two entities more akin to two entities just dealing at arm's length in the marketplace versus, you know, being more closely connected. Okay, slide 16, we're talking about literal familial identity of interest. When close family members all are business owners or business principals, does the SBA consider all of the companies that those close family members are involved with to be affiliated? And, you know, the first thing to keep in mind when we're talking about familial identity of interest, we're talking about close family members, you know, siblings, father, daughter, husband, wife. Extended family does not count for a familial identity of interest. And again, we're talking, because everything in the affiliation context is about control, superficial job titles don't matter. It's really about what if those close family members have the ability to exercise control over those separate entities. There is a possibility that there is going to be affiliation there, or at least a conversation with the SBA about whether affiliation is going on. Okay. Presumption of affiliation can be rebutted. As with many of these things, there's an opportunity for a rebuttal to show that the control or the connection or the identity of interest is in fact not occurring. If family members are estranged, you know, if you haven't talked to your brother in years, then, I mean, it's a sad state of affairs, but it may sidestep an affiliation issue. Or if the, you know, and the main thing is if the close family members respect the separation between the businesses and conduct those businesses accordingly, which I think is probably covered on the next slide. Nope, I'm going to go back one. So in terms of identity of interest, again, I guess a key point is, you know, even though family members may control multiple businesses, you know, we will look at the course of conduct of those businesses to see that they are in fact being treated separately. You know, they're not contracting, subcontracting together more than I guess in a minimal fashion, and things like that. There is a respect there for the division such that it does not give rise to a potential affiliation issue. Okay, and moving on to slide 18. Now we're talking about economic dependence. And again, in terms of taxonomy, whether you view this as a separate affiliation issue or a subset of identity of interest, that really doesn't matter, I guess, other than to try and keep these concepts separate in your mind. So either way, this is economic dependence, and it's this idea that if one company or entity is unduly reliant on the other for business and revenue stream, at some point that can be a form of control unto itself, right? Because, you know, your number one strategic customer, who's all important, to the vitality of your business, they're going to get their druthers on some things, and that could be seen as a form of control. Now, fortunately, this isn't a low threshold. It's usually looking at about 70% or more of the revenue from the previous fiscal year coming from that other business, potentially and it's a rebuttable presumption to show that it's actually the relationship is conducted in a way that control is being prevented. But so it's a fairly high standard, but it can occur, and it's all factual circumstances considered. So, for example, if you are a brand new small business startup, it's your first year of performance, you only have one contract with, say you're a subcontractor with a certain prime contractor, and it's 100% of your revenue stream at that point, you're just getting started. There's an understanding that doesn't kick up an economic dependence affiliation, unless, of course, there's other factual circumstances involved, such as, the wider facts and circumstances indicate that the two businesses will conduct themselves that way going forward, and that's just the intended path for the lifespan of the small business. Okay. Newly organized concern rule. Let's see, I think we are on number 5. So a newly organized concern rule is basically about spin-offs. If the small business is successful, as we hope it to be, it's going to grow, it's going to obtain more revenue, it's going to obtain more employees, and at some point it's no longer going to be a small business, but we don't want to give up the benefits of being in the small business program. So what do we do? Oh, I know. Let's create another small business that we can work with or work through, and we can get some economic vitality that way. Of course, this is another, just like the Trojan horse small business, this is another common strategy. And does it or does it not give rise to an affiliation problem? Well, of course, as most answers, it depends. But here's the 4 factors we look at. So if former officers, directors, principal stockholders, managing members, or key employees organize the second firm, and again, a key employee is somebody who's in a position of critical influence or substantive control. So control is control. Influence would be, say, you have some SME who just is the person who really is the keeper of the secret sauce, and they are so critical to the successful conduct of that business, even though they don't have control in terms of an ownership stake or a management control in that way. So there it is. At first, you have to have those people go over to the second company. Another key factor is that it has to be in the same or related industry. So if the second business, which is a small business that is spun off from the previous small business, is going into completely separate industry, it's not a problem. Let's see. So it's been organized by the former business, it's the same or related industry, and then of course, these individuals are serving in a position of control or key leadership or key influence in the second business. And then the 4th factor, there is assistance and resources being provided back and forth so that the relationship is continuing. It's not just that the other than small business that was formerly a small business spun off this new small business, and the other factors are present, but it's like, okay, well, we wish you luck with this endeavor, and they part company. That won't kick off an affiliation, but obviously that's not why, generally speaking, companies spin off a new small business. It's because they want to continue working with that new small business, so that 4th factor has to be present. If you have all 4 factors, you have a newly organized concern affiliation issue. Excuse me a moment. Okay, excuse me. Joint ventures. Now, this is obviously in the world of affiliation and small business rules generally, excuse me, is a hot topic because joint ventures are in vogue and the rules keep changing to be even more favorable to joint ventures. And generally speaking, unless the joint venture follows the strictures of the small business rules, they won't be considered affiliated, the joint venture partners, that is. So it's key that the joint venture partners follow the rules of the small business, laid out, and there's a lot of intricate rules when it comes to setting up a joint venture, that they follow and observe those rules. Otherwise, both partners, or if it's multiple partners to the joint venture, will be considered affiliated. So, and whether you're doing it under the new all small Mentor-Protégé program, or it's the old 8A Mentor-Protégé program is the basis of the joint venture, or if all the entities are small for the applicable size standard, then you're not going to have an affiliation. But again, it's you have to follow the rules strictly to make sure that is the case. And then, of course, with joint ventures, if you haven't heard it before, you've heard it here. There's a thing called the 3 and 2 rule. So, for example, if joint venture comes together, say it's under the all small Mentor-Protégé program, where you have an other than small business that is mentoring a small business protege, then that specific joint venture can only form or participate in they can pursue as many contract opportunities as they want, but they can only actually obtain and perform 3 contracts in 2 years. And what you'll see sometimes in this space is after a joint venture has obtained 3 contracts in 2 years, and if it went particularly well, the relationship between the partners, they may decide to form another joint venture, and then another joint venture. And this can go on for quite a while before it kicks in a totality of the circumstances affiliation issue. Okay, and here's some further details about the all small Mentor-Protégé program. Came into being in 2016, giving the Mentor-Protégé opportunity for all small businesses, not just specific socioeconomic programs like the 8A Mentor-Protégé program. It provides the same joint venture affiliation exception previously available only to 8A firms, which allows all small business protégés to form joint ventures with their large business mentors. Then mentor-protégé joint ventures, and again, this is assuming that the rules are being followed, qualify for all set-aside contracts for which the protégé is eligible. And again, dependent on compliance with the rules. Okay, now we are on to the Ostensible Subcontractor Rule, which I believe by my taxonomy is 1, 2, 3, 4, 5, 6, 7, 8. Excuse me, 7. This is baseball player number 7. So the Ostensible Subcontractor Rule is basically the idea that you have some subcontractor upon which you as a small business are unduly reliant to the point where it now is seen as an affiliation / control problem that's undercutting your small business size status. And this again is a very factual intensive inquiry. And of course, the details matter. So under the Ostensible Subcontractor Rule, again, subcontractor, the prime contractor, small business is unduly reliant upon the subcontractor, and that can create an affiliation problem. And here we kind of see the elements of it. They're particularly focused on whether that subcontractor is performing primary and vital requirements of the contract, or whether in fact the small business prime contractor is still taking on the main effort and adequately controlling the work, however that might be seen, so that it staves off an ostensible subcontractor affiliation. Okay, moving to slide 23. So SBA rule exempts similarly situated subcontractors from ostensible subcontractor affiliation. And this is because the small business program rules generally encourage similar situated contractors to band together, to obtain success and experience and resources. And that's not seen as frustrating the goals of the small business program, but promoting the goals of the small business program. And you can see similar situated, just to make clear for anybody who's not sure what that means. If it's a hub zone requirement, that means not only is the small business hub zone the prime contractor, but a small business hub zone is also the subcontractor. Similarly, if it's a service disabled veteran-owned small business, the ostensible subcontractor rule doesn't kick in if the prime sub relationship is between two service disabled veteran-owned small businesses, and so on and so forth, depending on the socioeconomic category. And then here's another important edification. Similarly situated entity must also be small. They must both be small for the NAICS code that the contracting effort is being performed under. And this happens sometimes where, depending on the procurement, but for the NAICS code, one business might be considered a service disabled veteran-owned small business, but for that NAICS code, they're just a service disabled veteran-owned business, not a service disabled veteran-owned small business. And then and this is a new rule that just came in December 30th, 2019, and we were kicking it around last year, and the final rule finally came out. SBA can now make a determination considering a small business program participants' over-reliance on a non-similarly situated subcontractor is part of an eligibility or status protest determination. Now, if you take that sentence in, it seems a little bit odd that the SBA wouldn't consider that before, but apparently it was a loophole that needed to be closed. Well, that loophole is now closed. The SBA OHA or SBA, forget the size appeal level, just at the size determination level, SBA can look and consider non-similarly situated small business subcontractor as part of the eligibility or status protest determination. And as established, as we're talking through this ostensible subcontractor rule, if the two small businesses are not similarly situated, they will not qualify for the exception. Okay, and then the next form of affiliation, franchise and license agreements. Happens quite a bit. I mean, if you understand the basics of a franchise agreement, the classic example would be, for example, a fast food restaurant, where you have the individual owners of that specific physical restaurant, but they're able to use the branding and marketing and advantages of being part of that chain of restaurants. And they do so because they sign a franchise agreement or license agreement to do so. Now, the thing about franchise and license agreements is, in exchange for being able to trade on that product or that brand or those resources, there are certain controls or considerations that are inserted into one of those agreements, and depending on what those are, it could undercut the control and in turn small business status of the small business entity. So when you're looking at potentially signing a franchise or license agreement, the details matter, the terms matter. You can't agree to terms which will undercut your status as a small business because you're conferring too much control on someone else. Now, there are some recognized restraints, which, although maybe gives away a little bit of control, is not seen to be a significant problem, such as agreeing to terms that standardize quality, agreeing to certain advertising, a certain accounting system, and similar provisions. Those are things which generally are to be expected in a franchisor or licensor agreement, so the franchisor or licensor can protect the quality of their brand and doesn't cut too far into decision-making vis-a-vis a specific contract. The franchisee or license agreement must ensure the franchisee or the licensee has the right to profit from its efforts and bears the risk of loss commensurate with its ownership. So again, in a franchise or license agreement, if one of the terms that the franchisor or the licensor wants the small business to agree to is getting a cut of profit, depending on what and how that is carried out, that could give rise to an affiliation issue. And of course, there's other issues that you might see in the context of a franchise and license agreement that a lot of these affiliation issues don't come in by themselves. Usually there's a couple types of affiliation issues in play if there's a problem. So it can create a common ownership affiliation issue, a common management affiliation issue. All these things might happen if a franchise or license agreement has undue terms. And then I think we're already here at the last type of small business affiliation, and this is kind of the catch-all. This is totality of the circumstances, and it's as it sounds. Even if one of the specific other types of affiliation is not in play, if the way the small business conducts itself vis-a-vis this individual or other entity is such that if you take up all the totality of the circumstances, there seems to be a control issue, which obviously means an affiliation issue, then the totality of the circumstances may cause an affiliation for the small business. So, that said, this is bullet point or block point number 2. SBA generally likes to look for affiliation on one of the more defined categories before it turns to the possibility of considering totality of the circumstances. And I can tell you, totality of the circumstances affiliation is fairly rare. I mean, the two businesses would have to carry on for quite a bit before the totality of the circumstances would lead to an affiliation. Now, the place where this is arising mostly these days is in the joint venture context. Again, joint ventures are very much in right now. And in that context, you see it raised on the 4th or 5th joint venture, sometimes between two entities, where basically the question is, have these guys worked together so much for so long and performed so many contracts together that even though each individual joint venture adhered to the rules and were properly considered small businesses, at this point, these two companies enjoy being together so much that should we just find them affiliated under the totality of the circumstances? Okay, that covers our categories of affiliation, and thank you for being patient. We'll go through some tips, and then I'd like to obviously field questions and make this more interactive. It's going to be more fun for everybody. Okay, so a couple of tips, couple rules of the road to think about as you're navigating the affiliation issues. Teaming agreements. Language matters, words matter, of course. This is stereotypical for me to say this as a lawyer, but it matters. So when you form your teaming agreement, you have to consider the terms of that teaming agreement to potentially stave off affiliation issues, and particularly ostensible subcontractor affiliation. When you're talking about the parties under the teaming agreement coming up with some concept of how the work is going to be divided up, who's going to be responsible for what, it's important for that small business in that teaming agreement to, for the small business prime contractor that is, to retain control of key components of the work to stave off a possible ostensible subcontractor affiliation issue. And it says it right here, to lessen vulnerability, your teaming agreement should make clear that the prime contractor is in charge of the project and performing key functions. And this obviously can get into some judgment calls and some gray matter. Some RFPs or some solicitations are obviously written better than others. Some lend themselves better to figuring out what is the primary and vital requirements than others. But some thoughtfulness should go into it, and terms crafted accordingly to ensure that the teaming agreement itself does not create a factual basis for affiliation. And then here's some tips about what SBA is kind of looking for in ostensible subcontractor cases. What was the degree of collaboration on the proposal? Is the subcontractor the incumbent contractor and ineligible to submit its own offer? Sometimes, yeah, when you're dealing with that prime contractor who's an other than small, or excuse me, that subcontractor who's an other than small business, who was the incumbent prime contractor and is now supporting a small business in performing that effort. It takes a little bit of extra care in how the parties conduct themselves, because it can lead to an ostensible subcontractor trigger. What are the more complex and costly contract functions? Which party will perform them? Will the subcontractor perform discrete tasks, or is there commingling of personnel and material? These are all considerations. Who possesses the background? Who has the experience? Who has the know-how? Again, is the focus is on control for the small business prime contractor. Are they in fact in control? Who's really driving the bus here? And, looking at all these different factors, very factual intensive, can be used to elucidate what is actually going on. And here's some more details on who prepared the proposal. And again, we're talking primarily for the ostensible subcontractor affiliation issue. The extent of the subcontractor's participation, again, who's driving the bus? Particularly in that situation I've already just mentioned, where the subcontractor is the incumbent from the previous iteration of the contract. They really have a lot of insight on how to put together a very good proposal, but the small business prime contractor should still take care to make sure that they are in fact in control. Of course, by itself, not necessarily determinative, but can be added with other facts as to whether there is in fact an affiliation issue. And it says it right here, subcontractor inquiries are intensely fact specific. So for example, I'll just read the example real quick. In an LPTA procurement that's lowest price, technically acceptable procurement, proposal references to a subcontractor's experience are less likely to create an ostensible subcontractor affiliation, because the subcontractor's experience would not materially enhance the offeror's prospects for award. Okay. Who's providing the key personnel? Another factor for consideration. Now, one thing that was an exception to this, and again, we're talking, in this context of where the large business subcontractor is the incumbent for the incumbent iteration of the contract, and the small business that's now working with the incumbent is potentially turning around and hiring all of their people who performed in the incumbent effort. There was an exception to that based on the old 2009 executive order, non-displacement of qualified employees, FAR clause, that came as a result of that, which actually required for those Service Contract Act or Service Contract Labor Standards statute covered positions that the new contractor had to actually provide right of first refusal to the incumbent personnel. Obviously, following the law should not penalize the small business prime contractor in terms of affiliation. So that was a fairly reliable exception. However, recently, and this goes back to October 31st of this past year, the president revoked the Service Contract Labor Standards right of first refusal rules by executive order. So it's questionable how reliable this exception is going to be going forward. Of course, there's still a right of first refusal rule in place if the continuity of services clause is in the solicitation or the contract. That could still kick off the right of first refusal rule, such that the small business prime contractor needs to extend and rely upon extend offers of employment and rely upon the employment of these incumbent personnel. But outside of a specific circumstance like that, just keep in mind the Service Contract Labor Standards right of first refusal is not there. So I'm not sure I'd rely upon that too much as an exception. Okay, and then we have is the second block bullet point, wholesale personnel transfers from the subcontractor to the prime contractor, and particularly the hiring of key management personnel, does create a significant risk. And again, being unduly reliant, having an ostensible subcontractor, this is where, we question the small business's ability to control things if they have to rely to this degree on that outside party. Okay, talking in the M&A context, which is we talked about under stock options, convertible securities, and M&A affiliation issues, corporate restructuring. A small business, once it's determined to be affiliated with another entity and saying after adding up their average gross receipts or their employees, that small business is in fact no longer a small business, it is not branded in that fashion for all time. Yeah, obviously relationships change, course of dealing changes, the nature of the business changes. If one is marked as affiliated, when small business is marked as affiliated, that affiliation can go away and lessen over time. And sometimes businesses will restructure, obviously, to get rid of an affiliation problem. And that's perfectly okay, and it's encouraged, and that's part of just minding one's relationship vis-a-vis the rules. Letters of intent. So a letter of intent, and as administrative note, we're on slide 31. Letters of intent, that's usually a writing that's used during the M&A process, so people aren't wasting time and energy and resources going through the due diligence of full M&A. At some point earlier in the process, a letter of intent is agreed to by the parties to make sure everybody's serious, and the legal enforceability of that letter of intent. I don't know enough about that. And it's going to obviously be fact dependent like any other contract document, and whether it's how definite the terms are. But besides setting that aside, a letter of intent can also be a problem in terms of small business affiliation, right? If it's too definite, it may kick off an affiliation issue earlier than intended in the M&A process. And if it does, as the M&A process continues, the small business then has to be mindful that it may no longer be a small business. Check your corporate records for negative control. And this is just a general good hygiene principle for ensuring that your small business has not become affiliated. Anything in your corporate governance documents or your business governance documents, such as supermajority provisions, where to do something, supermajority is required of not just the small business owner who may be the 51% owner, but to do something, it requires, say, 66% or 67% of the ownership interest to do it. That could be a form of negative control that could give rise to an affiliation issue. This tends to be very dependent upon what is the basis of the negative control, because even in this context of small business rules affiliation, it's acknowledged that minority owners, minority interest owners, have the ability to protect their investment to some level, and therefore not every single type of negative control necessarily gives rise to an affiliation issue. So when we talk about the types of issues that could potentially be proscribed or prohibited negative control issues, it's and you see it bullet listed here: hiring and firing of executive officers, setting executive compensation, power to approve a board member, and veto over board control over board committees. Excuse me. Now, the types of things, I'm going to back up, 32, the types of supermajority requirements that would not necessarily give rise to negative control would be extraordinary actions. And one of the extraordinary actions that typically is considered permitted is, you have a minority interest owner in the small business, they want to protect their investment. They don't want to be liable for potential malfeasance or imprudent decision making to a certain extent by the majority owner. So there might be a supermajority requirement that in order to obtain a loan of a certain size, there has to be a supermajority requirement in there. That type of thing where it's really not seen as the minority interest owner trying to control the day-to-day operations of the small business, but just protect the minority owner's business interest in the business. That typically will not give rise to an affiliation issue. Okay, and another tip, and this has to deal with in the stock ownership context. Again, if it's 50% or more, the idea that the individual who owns that 50% interest or more, or the entity that owns that 50% interest or more, is in control, that is not a rebuttable presumption. It's pretty much going to lead you directly to an affiliation finding. And again, if no single owner owns 50% of the stock, SBA will presume that each owner generally controls the company, but you have the opportunity to demonstrate otherwise. And this, going back to what we were talking about, this gets into relative levels of interest amongst the minority interest owners. And if everybody is seen as having too small of an interest, then the board or the officers are considered to be in control. So it can be somewhat fact specific when you're getting into minority interest owners where there is no majority interest owner. To rebut the presumption of control, you need to clearly demonstrate through your corporate documents and actual operations that certain owners do not participate and have no ability to control the company. Okay, and here we go on economic dependence, which can be seen as a form of identity of interest affiliation or not, depending on how you organize this in your mind. We look at the 70% rule. When 70% of your or more of your revenue comes from another company, obviously, as any healthy business, having diverse interests, having diverse relationships, having diverse opportunities is generally considered to be helpful. So you want to try and avoid being reliant to that degree on business coming from any one outside entity. Of course, you can show a fracture in economic dependence, again, if the way the parties conduct themselves is they respect that separation between the two businesses, they respect the control of the small business, and the small business has not put itself in a position where it cannot walk away from the relationship. If certain controls are respected and maintained, then that economic dependence may not be undue, may not kick off an affiliation issue. Okay, what if my family member owns a business? Right now, we're still talking identity of interest affiliation by family member. It is rebuttable. I mean, one of the tips here, stop inviting them to Thanksgiving dinner. I'm pretty sure that's a joke. You don't need to stop inviting your family members to Thanksgiving dinner. That has nothing to do with ownership or control of the small business. Keeping the business separate and distinct. That's really the key. Is if your sister owns a company, your brother owns a company, your parents own a company, if your son or daughter owns a company, treating those businesses, their business and yours, as separate and distinct, at least mostly separate and distinct. It doesn't mean that the businesses can never interact, but it should do so in an arm's length, dispassionate way, and probably be infrequent. That type of course of dealing, that's how you're going to rebut a family member identity of interest affiliation issue. If you're a new concern, what is new? Good rule of thumb, 3 years or less. Just be mindful of where you previously worked. What was your possession? The extent to which your company has an ongoing relationship with your former employer. Um, all good tips. I mean, again, the idea is you don't want to be a Trojan horse doing the bidding of another company. Even though you may have had positive relationship with that other company, and of course, as a business person, you want to maintain a good relationship, but that needs to be conducted in such a way that you maintain control of your small business and you are not unduly reliant on that other business. And again, we have the 4-factor test. And, so if you were not an officer, owner, director, key employee of the previous employee, if your company is not receiving any financial or other ongoing assistance, or the other 4 factors, the other 2 factors, out of the 4 are not present, then it's not going to be a problem for this type of common management, or newly organized concern affiliation issue. Okay, and just like we were talking before, is one rule of the road. Make sure you're using the right terms and language in your teaming agreement. Same thing for a joint venture agreement, except here it's even more precise because the regulations prescribe certain things that joint venture agreement has to cover to be recognized as a joint venture that does not give rise to an affiliation issue, and also avoiding other provisions that may undercut those key provisions that are supposed to be in the joint venture agreement. This is key. This is important, again, to staving off an affiliation issue. And we have an example of a case here, recent case, 2014. SBA rejected a Mentor-Protégé joint venture because the joint venture agreement did not clearly explain what each party would do in performing the contract. That's under the regulations. Those are one of the terms of a joint venture agreement that needs to be covered to a certain level of adequacy. And then other JVs have been rejected for incorrectly designating where the JV records will be kept. Again, where the joint venture records will be kept. That's a key provision in a joint venture agreement. And basically, they need to be kept with the protege. Not identifying a project manager by name, also required under the regulations. Not specifying rules for contract negotiation, sources of labor, also discussed as needing to be in a joint venture agreement by the regulations. Okay, we're almost there, almost to the interactive portion. So basic summary points. Understand what affiliation is. Again, I mean any relationship, any connection to a person or entity outside your small business potentially could give rise to an affiliation issue. However, it's all about control. It's just a question of is the relationship or is the connection or is the transaction such that it's potentially undercutting the control by the rightful small business owners or the folks who should be controlling that small business. That's what we're talking about with affiliation. Keep viewing it through that lens and keep an open mind, and that should help you identify potential issues. Again, proactively assess potential issues in transactions, whether you're dealing in the M&A context, whether you're doing a teaming agreement, whether you're doing a joint venture agreement, being on the lookout for potential issues, viewing the documents through that lens to see if there's potentially triggering an issue. This is important. And as part of this, of course, looking for negative controls. This negative controls usually will be present either in a mentor-protege agreement potentially, or a joint venture agreement if the joint venture agreement gets more into governance of the joint venture or the small business. And of course, M&A terms, any types of things which may actually ascribe controls and mechanisms for a certain decision making. Keep an eye on that through the affiliation lens. Diversifying your teaming partners and sources of revenue. Again, not becoming unduly reliant on this entity or that entity. This is maintaining your independence as a small business. The spirit of that animates all of these rules. And family members. Don't automatically assume that your family member's business is unaffiliated with your firm, but at the same time, that doesn't mean you need to be jumping at every potential shadow. I mean, obviously, if you have a family member who owns a business, it's in a completely different industry, their business never interacts with your business, it is probably not going to be an issue. And then, this is more of an optics thing, but optics things can lead to real problems. Make sure your website marketing materials don't create a misimpression of affiliation.